Chief Justice Rehnquist, with whom Justice Scalia and Justice Thomas joined concurring. We join the per curiam opinion. We write separately because we believe there are additional grounds that require us to reverse the Florida Supreme Court's decision. We deal here not with an ordinary election, but with an election for the President of the United States. In most cases, comity and respect for federalism compel us to defer to the decisions of the state courts on issues of state law. That practice reflects our understanding that the decisions of the state courts are definitive pronouncements of the will of the states as sovereigns. Of course, in ordinary cases, the distribution of powers among the branches of the state government raise no questions of federal constitutional law, respect, or subject to the requirement that the government be Republican in character. But there are a few exceptional cases in which the Constitution imposes a duty or confers a power on a particular branch of the state's government. This is one of them. Article 2, Section 1, Clause 2, provides that each state shall appoint in such manner as the legislature thereof may direct electors for president and vice president. Thus, the context of the election law itself, and not just interpretation by the courts of the states, takes an independent significance. 3. Title 3 of the United States Code, Section 5, informs our application of Article 2, Section 1, Clause 2 to the Florida statutory scheme, which, as the Florida Supreme Court acknowledged, took the statute into account. Section 5, that the state's election of electors shall be conclusive and shall govern in the counting of electoral votes if the electors are chosen under laws enacted prior to election day, and if the selection process is completed 6 days prior to the meeting of the Electoral College. As we noted in Bush v. Palm Beach County Canvassing Board, since Section 5 contains a principle of federal law that would assure finality of the state's determination if made pursuant to a state law in effect before the election, a legislative wish to take advantage of the safe harbor would counsel against any construction of the election code that Congress might deem to be a change in the law. If we are to respect the legislature's Article 2 powers, therefore, we must ensure that the post-election state court actions do not frustrate the legislature's desire to attain the safe harbor provided by Section 5. In Florida, the legislature has chosen to hold statewide elections to appoint the state's 25 electors. Importantly, the legislature has delegated the authority to run the elections and to oversee election disputes to the Secretary of State and to the state circuit courts. Isolated sections of the code may well admit of more than one interpretation, but the general coherence of the legislative scheme may not be altered by judicial interpretation so as to wholly change the statutorily provided apportionment of responsibility among these various bodies. In any election but a presidential election, the Florida Supreme Court can give as little or as much deference to Florida's executives as it chooses, so far as Article 2 is concerned, and this court will have no cause to question the court's actions. But with respect to a presidential election, the court must be both mindful of the legislator's role under Article 2 in choosing the manner of appointing electors and deferential to those bodies expressly empowered by the legislature to carry out its constitutional mandate. In order to determine whether a state court has infringed upon the legislature's authority, we necessarily must examine the law of the state as it existed prior to the action of the court. Though we generally defer to state courts on the interpretation of state law, there are, of course, areas in which the Constitution requires this court to undertake an independent, if still deferential, analysis of state law. This inquiry does not imply a disrespect for state courts, but rather a respect for the constitutionally prescribed role of state legislatures. To attach definitive weight to the pronouncement of a state court when the very question at issue is whether the court has actually departed from the statutory meaning would be to abdicate our responsibility to enforce the explicit requirements of Article 2. Acting pursuant to its constitutional grant of authority, The Florida legislature has created a detailed, if not perfectly crafted, statutory scheme that provides for appointment of presidential electors by different election. By direct election. In its latest opinion, however, the court empties certification of election results as prescribed by Florida law, virtually all legal consequence during the contest, and in doing so, departs from the provisions enacted by the Florida legislature. The court determined that canvassing board's decisions regarding whether to recount ballots past the certification deadline are to be reviewed de novo through the election code, although the election code clearly vests discretion whether to recount in the boards and sets strict deadlines subject to the Secretary's rejection of late tallies and monetary fines for tardiness. Moreover, the Florida court held that all the late vote tallies arriving during the contest period should be automatically included in the certification regardless of the certification deadline, thus virtually eliminating both the deadline and the Secretary's discretion to disregard recounts that violate it. Moreover, the court's interpretation of legal vote and hence its decision to order a contest period recount plainly departed from the legislative scheme. Florida statutory law cannot reasonably be thought to require the counting of improperly marked ballots. Each Florida precinct before Election Day provides instructions on how properly to cast a vote. Each polling place on Election Day contains a working model of voting machines it uses, and each voting booth contains a sample ballot. In precincts using punch card ballots, voters are instructed to punch out the ballot cleanly. After voting, check your ballot card to be sure your voting selections are clearly and cleanly punched and there are no chips left hanging on the back of the card. No reasonable person would call it an error in the vote tabulation or a rejection of legal votes, according to the citations in the statute. When electronic or electromechanical equipment performs precisely in the manner designed and fails to count those ballots that are not marked in the manner that these voting instructions explicitly and prominently specify, the scheme that the Florida Supreme Court's opinion attributes to the legislature is one in which machines are required to be capable of correctly counting votes, but which nonetheless regularly produces elections in which legal votes are predictably not tabulated, so that in close elections manual recounts are regularly required. This is, of course, absurd. The Secretary of State, who is authorized by law to issue binding interpretations of the election code, rejected this peculiar reading of the statutes. The Florida Supreme Court, although it must defer to the Secretary's interpretation, see Krivenik v. Take Back Tampa Political Committee, rejected her reasonable interpretation and embraced the peculiar one. But as we indicated in our remand of the earlier case, in a presidential election, the clearly expressed intent of the legislature must prevail, and there is no basis for reading the Florida statutes as requiring the counting of improperly marked ballots, as an examination of the Florida Supreme Court's textual analysis shows. For the court to step away from this established practice prescribed by the Secretary of State, the state official charged by the legislature with responsibility to obtain and maintain uniformity in the application, operation, and interpretation of the election laws, was to depart from the legislature's seat. The scope and nature of the remedy ordered by the Florida Supreme Court jeopardizes the legislative wish to take advantage of the safe harbor provided by Title III of the United States Code, Section 5. December 12, 2000 is the last date for a final determination of the Florida electors that will satisfy Section 5. Yet, in the late afternoon of December 8, 4 days before this deadline, the Supreme Court of Florida ordered recounts of tens of thousands of so-called undervotes spread through 64 of the state's 67 counties. This was done in a search for elusive, perhaps delusive, certainty as to the exact count of 6 million votes. But one claims that these ballots have not previously been tabulated. They were initially read by voting machines, but at the time of the election and thereafter re-read by virtue of Florida's automatic recount provision. No one claims there was any fraud in the election. The Supreme Court of Florida ordered this additional recount under the provision of the election code given the circuit judge the authority to provide relief that is appropriate under such circumstances. Surely, when the Florida legislature empowered the courts of the state to grant appropriate relief, it must have meant relief that would have become final by the cutoff date of Title III of the United States Code, Section 5. In light of the inevitable legal challenges and ensuing appeals of the Supreme Court of Florida and petitions for certiorari to this court, the entire recounting process could not possibly be completed by that date. Given all these factors, and in light of the legislative intent identified by the Florida Supreme Court to bring Florida within the safe harbor provision of Title III of Section 5, the remedy prescribed by the Supreme Court of Florida cannot be deemed an appropriate one as of December 8th. It significantly departed from the statutory framework in place on November 7th and authorized open-end further proceedings which could not be completed by December 12th, thereby preventing a final determination by that date. For these reasons, in addition to those given in the per curiam, we would reverse. God, there's like 10 more pages. All of the justices opined on this. I'm not sure that I'm going to read anything from Justice Stevens and Justice Ginsburg and Justice Breyer joined dissenting. And Justice Souter, Justice Breyer joins with Justice Stevens, Ginsburg join with regard to all but Part C dissenting. Justice Ginsburg, Stevens, Souter, and Breyer join as a Part 1 dissenting. So they must have different ways to determine this. I'm going to read the last section. Issues to consider concerning Bush versus Gore. There are many issues to consider regarding Bush versus Gore. First, was the case justiciable? Gore did not raise justiciability issues in his briefs or at oral argument, yet justiciability is jurisdictional. The court must raise it on its own. The question is whether Bush has standing to raise the equal protection claims of the Florida voters. Also, was the case ripe for review at the time it was decided by the Supreme Court? Should the court have found that the matter was a political question and left to Congress to resolve? Second, was the court correct in finding a denial of equal protection? Seven of the justices expressed concern over the denial of equal protection from counting votes without uniform standards. However, it is notable that Justice Souter and Breyer, who shared this concern with the majority, did not file opinions concurring in part and dissenting in part, but rather just dissented. How exactly was equal protection denied? Third, was the court justified in ending the counting in Florida? The court, in its per curiam opinion, said that the Florida Supreme Court had indicated that it wanted to follow the December 12th deadline set by the federal safe harbor statute. Because it was December 12th, the Supreme Court ordered an end to the counting, but because it was an issue of Florida state law, should the Supreme Court have remanded the case to the Florida Supreme Court to decide the content of Florida law under the unprecedented circumstances? On December 13th of 2000, the day after Bush versus Gore was decided, Al Gore conceded the election to George W. Bush. Rightly or wrongly, for the first time in history, the Supreme Court decided a presidential election.